To you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Illinois, and we're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hi everyone, this is Matt with Learn About Law, and in this video I'm going to discuss recent changes to Illinois probate law that may affect you in 2021, specifically the Illinois Parentage Act, including what is the Illinois Parentage Act and what are the rights of children who have been born after their parents have passed away. The Illinois Parentage Act was passed recently by the Illinois legislature within the past couple of years, and it provides a major improvement to probate law in the area of posthumous children. A posthumous child would not be deemed a decedent's child for inheritance purposes unless the child was in utero at the time of death, according to the new provisions. Despite the fact that this is the default rule in Illinois, testators have the option to make other provisions in their wills. It can be difficult to write a will or trust, particularly if the testator owns a lot of land. So if you or a loved one are thinking about writing a will or need to change one, you should hire an experienced estate planning lawyer who can make sure that all of your heirs are taken care of in the event of your death. The rights of children who have been born after their parents have passed away, unless the testator expressly given otherwise in his or her will, a child born from in vitro fertilization cannot inherit under the Probate Act if the implantation occurred after the decedent's death. Alternatively, even though a testator did not decide what should be done with an inheritance in this case, he or she would always rest easy knowing that any unborn children would be cared for. Legislators were largely motivated by public policy, which acknowledges that all children have the right to their parents' physical, mental, emotional, and financial care. As a result, posthumous offspring, as long as they were in utero at the time of the decedent's death, are automatically entitled to the same share of an estate as if they had been born during the decedent's lifetime. Unfortunately, this means that if a man or a woman uses a decedent's egg or sperm to reproduce by in vitro fertilization after the decedent has passed away, the child would not count as a child under Illinois inheritance law, despite being the biological offspring of the decedent. Again, this is just the state's default rule, so testators are free to write a will that includes alternative provisions for any children who have yet to be born. Estate planning can be challenging, particularly when testators must care for children who have not yet been born. However, it is important to address these topics when arranging an estate to ensure that all of a decedent's loved ones, regardless of when they are born, are cared for. Thanks for watching. To learn more about recent changes to Illinois probate law that may affect you in 2021, check out our article linked below. Be sure to leave any questions you have in the comments and subscribe for more legal content daily.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 630-324-6666. We have many locations for your convenience and we serve all of Illinois. So thanks again for watching.